Hello, everyone, and welcome to Thursday Talks with Chug. Each week, we cover pressing topics that matter to you and your business. I'm Arianna Gonzalez from Chug Attorneys and CPAs, tuning in from our San Diego office. Please join me in welcoming partner and attorney Min Kim from our Edison, New Jersey office and immigration attorney Belma Burkic from our Houston, Texas office. Hi there, Min and Belma, and welcome.
Hello.
Hello, Ariana. Thanks for having us again.
Thank you for being here. For today's topic, we will be diving into the new immigration programs designed to help certain undocumented spouses and children of U.S. citizens, as well as DACA recipients and other dreamers. Just a quick disclaimer before we get started. We are live on YouTube, LinkedIn, and Facebook. This conversation is for informational purposes only and does not create an attorney-client relationship, so please comment your questions below or email us at info@chug.com so we can help you out. Now let's get right into it. I must admit that today's Thursday live session is one that I've been looking forward to ever since President Biden made headlines in announcing the Parole-in-Place executive action for undocumented spouses and children, and simultaneously announced some huge changes to come for DACA recipients. The news coverage has basically been nonstop, with major news media outlets covering both executive action announcements since they were first reported last week. In the interest of time, if you both don't mind, I would prefer to just dive right into it. Min, let's start with you. What does our audience need to know about President Biden's Parole-in-Place program for undocumented spouses of U.S. citizens?
The parole in place relief effort is, I agree with you, definitely one of the more ambitious and far-reaching immigration relief programs to have been announced in recent years. So I can understand your enthusiasm. In the White House's press release last week, the White House estimated that this parole in place relief program can potentially protect around 500,000 spouses of U.S. citizens and approximately 50,000 non-citizen children under the age of 21 whose parent is married to a U.S. citizen. So we're talking about a large population of undocumented individuals living in the U.S., contributing to society and our economy, who might finally have a defined and direct path to receiving their U.S. green cards without having to leave the United States first, meaning that they can apply directly with USCIS to adjust their status to permanent residence. And as it stands right now, the eligibility criteria for qualifying for this government relief, in my opinion, is rather straightforward. So how does one become eligible? Well, one, that non-citizen spouse must be present in the U.S. without lawful admission or parole. Two, the non-citizen spouse must continually have lived in the U.S. for at least 10 years as of June 17th, 2024. Three, the non-citizen spouse must be legally married to a U.S. citizen as of June 17, 2024. Four, the spouse must not be a threat to public safety or national security. Five, other than being undocumented, that spouse must be eligible for adjustment of status in applying for a green card. Let's say someone with an extensive criminal history, for example, will probably not be eligible. And six, the totality of the circumstances surrounding the application and the spouse should merit a favorable exercise of discretion on the part of USCIS. And thus, if a spouse meets all six of these eligibility criteria, then presumably the spouse and by extension, any stepchildren under the age of 21 should qualify for the parole in place program that will provide a 3-year period for the spouse and children to apply to adjust status to that of U.S. permanent residence. And during this 3-year period, they will also be eligible for employment authorization and be protected from removal.
Wow, this is certainly exciting news. So I can now understand why those media outlets have been reporting on these developments so often within the last week. The Parole in Place program provides relief to those undocumented spouses of U.S. citizens who, might have entered the U.S. without inspection before and who are continually looking over their shoulders in fear of being separated from their families. Belma, is there anything you want to add to this groundbreaking piece of news?
I think you captured it perfectly, Ariana. It is groundbreaking because these folks no longer need to depart the United States and consular process their green cards. Traditionally, if an individual entered the United States without inspection, a green card based on marriage to a US citizen was still potentially possible, but it required the individual to leave the US and file for an immigrant visa with the consulate in order to return. This also extended to stepchildren. The issue was that depending on the accentuating circumstances involved, those spouses would be subject to certain lengthy bars from returning to the US, so up to 10 years in some cases. And so this parole-in-place program undoes that prior need to leave the US or file for a lengthy waiver for those eligible non-citizen spouses and children. Now they're allowed to remain in the United States, not risk being separated from their families and loved ones, and can go through the US permanent residency process from within the familiar settings of their hometowns and not depart their homes.
It certainly appears to promote family reunification and putting steps in place to ensure that the family unit stays together. How early can non-citizen spouses and children look to apply for this PIP relief?
Well, it hasn't officially launched, but the White House is on record of saying that it intends to roll out the program in late summer this year. So, in the lead up to the program start date, I anticipate Homeland Security to post a public notice that provides application instructions and further details on how one can be eligible for the relief. As with most things immigration, a benefit request like this one for parole-in-place will involve a USCIS form to be completed along with payment of the required government filing fee.
Wow, late summer, that's actually really soon. Well, I suppose for families who might find themselves in these situations for years, if not decades, the program launching cannot come soon enough. But to hear perhaps within the next couple of months, this PIP relief program will be publicly available is very exciting.
It is, but I would caution the audience to be somewhat measured in their enthusiasm, perhaps. Because we're talking about wide-scale benefit to a rather sizable immigration population, things can potentially go sideways in the form of lawsuits and court actions that are filed with the purpose of delaying the implementation of the program. And the question I have for those folks who might be on the other side and resisting the Biden administration's PIP relief program, for those specific advocacy groups, why would a delay in the program start date be just as effective as killing the program altogether?
Let me guess, because it's an election year and we might have a new president in the White House who can just as easily undo the PIP program as President Biden started it with this executive action announcement.
Precisely.
Well, I guess I should know by now that in the world of immigration, if it appears to be too good to be true, it often is.
Yeah, I suppose there's some truth in that. But I do want to add, though, if I may, that I believe that the news is still overall very exciting. It's promising that the Biden-Harris administration is taking meaningful, unprecedented steps in providing options for undocumented individuals. It's true that we simply don't know what court challenges and implementation delays will arise. But as of now, I still consider this a positive step forward for pro-immigration advocacy groups. One thing I do want to remind our audience, though, is that the parole-in-place program is not in effect. We don't even know what the application procedure looks like at the moment because, as Belma shared, it's not expected to be publicly released until later this summer, in August perhaps. As some within the audience might know already, the typical Form I-131 is the parole application, but for this PIP for undocumented spouses and children, is it just a matter of filing the same I-131 form? It's virtually impossible to say, as we simply don't know what forms and what evidence USCIS is looking for in adjudicating these parole-in-place applications once this program is officially launched. That is why it's so important for potential applicants, those spouses and children who are undocumented and who might have entered the US without permission so many years ago, to guard against anyone in the legal profession, whether it be, let's say a legal consultant or notario or whoever who happens to make grand promises of getting a head start on the application process, or guaranteeing immediate results. There is no such thing. Nothing is officially released now, nor in effect.
That's certainly good advice there, Min. Thank you for reminding our audience to be on their guard. For something as widespread and potentially beneficial as this PIP program, there's always those unscrupulous individuals who might want to prey on the vulnerable, so it is critical that eligible spouses and children be on guard. Is there anything else you'd like to add before we pivot to talking about DACA recipients and the changes involved for such graduates to apply for a work visa?
Yeah, just really quickly. I suppose one thing I don't think we covered is how, if and when the PIP is granted to an undocumented spouse married to a U.S. citizen and granted to that same undocumented stepchild, Homeland Security would not be able to, whether Homeland Security will be able to rescind or take that parole in place away. What I mean by this is that especially since we are rather confident that litigation and court challenges to the program will happen. I even heard that former Trump advisor Stephen Miller is part of an advocacy group right now that is looking to raise funds in filing a lawsuit to stop the PIP program from being launched. Whether those non-citizen spouses and children should know that once their parole applications are approved, will they remain approved? Even if a court were to temporarily pause the PIP program, or perhaps a new president were to be elected and decide to undo this parole-in-place relief for undocumented spouses. The one interesting thing is that the fact that you were able to file your PIP application and get it approved before these obstacles in effect undo the program, as of now, my understanding of the announcement is that it means that your parole-in-place program remains unaffected. And those 3 years you have in applying for U.S. permanent residency and attaining your green card remain. So in a way, once we have more information from USCIS on what the application process looks like for the PIP program, it's rather essential for those eligible spouses and children to sort of hustle and get their applications in, assuming the parole-in-place program remains intact and not struck down by the federal courts at its early stages. But even though, right now that's the preliminary understanding of the White House's announcement, I do want to stress that much is still unknown since the program hasn't been officially launched yet, obviously. So even this grant the PIP, once they're approved, the White House might walk it back once the full set of details is released.
That's really good to know, man. And I appreciate you sharing such practical advice with our audience. But even with that said, going to your earlier point, it doesn't mean that eligible applicants should seek out anyone in the legal profession right now who promise instantaneous results and are looking to scam those spouses and kids, because it does unfortunately happen.
Yeah, absolutely, it does. The audience should know that nothing can be promised now, and no meaningful results can be secured now. But once the application effective date is released by Homeland Security and the procedure set in applying, those eligible applicants should look to get their PIP applications in as early as possible.
Mm. Belma, what about you? Is there anything you want to add as we wrap up on our parole in place discussion?
I would add that parole in place is only meant to be for 3 years. There doesn't seem to be an extension beyond these 3 years. At least that's what we know now based on the White House announcement. It could be subject to change once a more formal procedure is set, but for now, parole in place is expected to be granted as discretionary relief on the part of USCIS to allow eligible undocumented spouses and children to apply for their green cards. The PIP, once approved, will be granted for 3 years, and the spouse and any eligible children should apply for their green cards during this time, as once the 3 years expire, the eligibility window will have closed. It's meant to be discretionary relief on the part of USCIS to permit spouses and children of US citizens to simply remain in the United States for family unification purposes. So if that spouse and child do not take advantage of this PIP opportunity once approved, they lose the benefit and are then forced to rely on the old way of securing US permanent residence by needing to leave the US and consular process their immigrant visas, as well as secure all those waivers and worry about those 10-year bars that come with this.
That's a really good point. If I may, eligible applicants, they should know that parole in place is not some quasi status that the applicant can remain in forever and not worry about deportation, et cetera. It's a pathway to attain legal permanent resident status in the US. And once the parole is granted for 3 years, they must go to that next step in applying for the green card. I would just add that, those numbers I shared earlier, 500,000 undocumented spouses, 50,000 undocumented children, they're estimates on the part of Homeland Security and the White House, and not meant to serve as any kind of cap to the number of applications USCIS expects to receive for this PIP program. If you've been in immigration for any sort of time, as Belma and I have, you know all about caps, the annual H-1B quota and lottery selections, immigrant visa number caps for green card applicants. But for parole in place, at least from this preliminary announcement, from what we can glean now, it doesn't appear that USCIS intends to place any kind of artificial cap on the number of parole applications it receives. It will truly be first in and first out. If Homeland Security's estimates are low, and let's say, in fact, 600,000 spouses, not 500,000, but 600,000, submit their PIP applications, then presumably all 600,000 should be receipted and adjudicated as to whether that benefit should be granted.
But this is assuming that the program is not struck down by the courts or removed by a new incoming president, though, right, Min?
That's right, Arianna. Now you're catching on.
Okay, I do want to get to our dreamers and DACA recipients and what they have to look forward to. But one thing I don't get, and Belma, perhaps you can help me answer this. I understand that the Parole in Place program is not yet in effect. It hasn't been launched yet. We just know it's coming, and more information will be released by USCIS this summer. But despite that, why can't eligible spouses and kids perhaps get a head start in the application process? Don't these same individuals need to apply for their I-130 petition, or I guess have their US citizen spouse and parent apply for the I-130? It seems reasonable to me that while those spouses and kids wait for further USCIS instructions on the PIP program, for the things they know now and can control, for them to get a head start. Any thoughts regarding that?
It's a fair point, Ariana, and I get it. Many of these undocumented spouses have been waiting years, decades even, for a chance to apply for their green cards, but because of the current immigration rules in place, haven't been wanting to risk leaving the US only to perhaps be told that they cannot return to the US immediately because they triggered a statutory bar. Thus, wanting to expedite in certain areas like filing the I-130 petition and getting that paperwork ready might at first glance appear to make sense, but USCIS has gone on the record saying that the PIP must first be filed and granted before the immigrant petition and adjustment of status application can be filed. I get it. Everyone is eager to hurry the process along and for very legitimate reasons. But here again, this is where caution should be applied because we simply don't know what it's going to take to get the PIP approved in the first place. And knowing that once the PIP is granted, the spouse and child or children, if any, have 3 years to concurrently file their I-130 petitions and their I-485 adjustment of status applications, it would appear to me that the period of time, 3 years, is more than sufficient to fit in those final few steps in securing the green card approval. Jumping the gun and agreeing to have some unscrupulous individual get a head start on your I-130 petition when we don't even know what the PIP program will look like is rather dangerous, and it could very well do more harm than good.
Very convincing and very true.
Yeah, I mean, I would agree with all of that. I suppose perhaps one thing that can add though is, if the spouse truly wants to get a head start, then maybe one thing we do know now is that proving 10 continual years of being in the U.S. without ever departing during this time, that proving that period is going to be required. 10 years is a long time. Can the spouse get a head start in securing documentary evidence of how he or she has resided in the US continually without interruption for those 10 years? Proof of residence in the form of property information, tax records, school enrollment documents, bank statements, etc. All of that will go a long way in proving this uninterrupted period of 10 years residing in the US. That's a lot of paperwork to go through. So for those who are really eager and want to do something right now, I personally don't see any harm in getting a head start in trying to gather as much documents and have everything ready to file once that filing period is officially open.
Okay, I think we covered the Parole-in-Place program for undocumented spouses and children enough. So let's pivot to the second bit of executive action news that President Biden announced last week. Belma, would you be able to speak to what our dreamers and other U.S. college educated students can expect?
Yes, absolutely. So, on the same day when the White House announced the executive action of parole in place for undocumented spouses and children of U.S. citizens, it also announced a relief program to better streamline the work visa application process for certain U.S. college graduates, including DACA recipients. So, mainly eligible individuals, including dreamers, who have degrees from accredited U.S. institutions of higher education and who have received an offer for high skilled employment from a U.S. employer related to their degree can potentially expect a smoother and quicker process in obtaining a waiver when first applying for a work visa from a consulate abroad and entering the U.S. to work in their specialized field of employment.
That's all helpful to know, Belma, but to be honest, still somewhat vague. Is there more that you can tell us about the administration's plans for making it easier for these college graduates?
That's the thing, though, Ariana. Not much is known beyond these preliminary and overall very broad details. For parole in place for undocumented spouses, the executive action at least detailed the parole vehicle the administration plans to use in granting this quasi status for eligible spouses and children to quicken their approved green cards. This announcement pertaining to streamlining the work visa process for US college graduates is still very vague. But if I were to speculate, it doesn't appear that a new benefit like a parole in place is being carved out and created by the government. This is more of a clarification of current existing policy so that consular officers abroad, who are the ones processing these work visa applications like the H-1B, will have a fuller understanding of when to recommend a waiver of ineligibility to the Department of Homeland Security so that the H-1B visa can be quickly approved. So in days or weeks instead of months or years, and the passport timely returned to the college graduate so that he or she can return to the US and to their employer. You have to remember DACA recipients are students and young professionals who, legally speaking, are undocumented and residing in the US unlawfully because of this. And because of this undocumented status, oftentimes are ineligible to receive a US visa, like an H-1B non-immigrant visa, even though they would otherwise qualify for it. And the reason for that is in order to receive such a visa, the ineligibility bars have to be removed or waived by Homeland Security. And the specific waiver in question is typically called a D3 waiver, and it derives its name from the statute at INA Section 212 D3. And essentially, this D3 waiver is a rather broad inadmissibility waiver provision that excuses a wide range of grounds of inadmissibility to the US, including situations where either the 3 or 10-year bars might apply. And in the case of certain Dreamers and DACA recipients, they fall within this classification since they were brought to the US at a young age, either without inspection or perhaps overstayed, resulting in bars applying to them if they ever stepped outside of the US. So in the end, once a D3 waiver is approved by Homeland Security, it would allow Dreamers to obtain a temporary work visa like an H-1B from a consulate abroad, and then use that entry and the resulting valid H-1B visa admission to reinstate themselves into a lawful work authorized status. Now, that's how the process is supposed to go. But in reality, the waiver process is rather unpredictable and oftentimes very time consuming. And so the announcement from the White House and the accompanying FAQs released by DHS and Department of State is welcome news because they confirm that both agencies will work together in speeding up the waiver and visa application process overall so that these qualifying postgrads are not stuck waiting for long government processing times just in order to receive their H-1B work visas and their passports.
Okay, so if I'm following you correctly, it doesn't appear any new immigration benefit has been created. It's just the federal government's acknowledgement that this area of the law can be worked on, and jointly, DHS and the State Department will ensure that the requisite ineligibility waivers will be attended to much quicker than before.
That's right. In fact, in the same FAQ, the Department of State, in very express terms, was clear in conveying that no new benefits are being conferred as part of this clarification of existing waiver recommendation processes on their end, and also that these changes are not limited to just DACA recipients, but other college graduates and Dreamers who might benefit from such changes. I suspect that for the limited population this will impact, it will reduce the current hesitation or reluctance on the part of some of these individuals of departing the US and applying for a work visa because it will provide more certainty to these applicants.
Hmm. Any news in terms of implementation? Are we still looking at the same timeline as for PIP for undocumented spouses and children? Min, let's go to you. Late summer?
Actually, it might be earlier than that. The Department of State is on record of saying that it intends to make changes to their Foreign Affairs Manual, which essentially is their policy manual and instructional guide to consular officers within 30 days. So implementation of this change might actually be right around the corner. And unlike the executive action pertaining to undocumented spouses and children, DACA recipients and Dreamers overall, both groups, they share bipartisan support. So attempts at blocking something like that in the courts, it might not be so successful.
That's certainly welcome news, and hopefully for our audience, our live session today has been informative and eye-opening. It certainly has been for me, and that's all we have time for today. So as always, thank you so much, Min and Belma, for joining us today. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. If you have any questions or suggestions, please email us at info@chuk.com. We'd love to help you out and take your suggestions into consideration. And join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care. Thank you so much, everyone, for joining us. And special thank you to you, Min and Belma.